the behavior of a person arouses misunderstanding that he is a partner in a firm, that is, when actually he is not, such a person is estopped for later on denying the liabilities for the acts of the firm. Such person is called partner by estoppel and is liable to all third parties. Similarly, if a person who is declared to be a partner, that is, when actually he is not, does not deny the fact that he is a partner, he being held out as a partner is responsible for all liability of the business. The law relating to partners by holding out is contained in section 28 of the Act, which lays down anyone who by words spoken or written or by conduct represents himself or knowingly permits himself to be represented to be a partner in a firm is liable as a partner in that firm to anyone who has on the faith of any such representation given credit to the firm, whether the person representing himself or represented to be a partner does or does not know that the representation has reached the person so given credit. The rule as to holding out is based on the doctrine of estoppel as contained in section 115 of the Indian Evidence Act. Holding out means to represent. Strangers who hold themselves out or represent themselves to be partners in a firm whereby they induce others to give credit to the partnership are called partners by holding out. An active partner who fails to give public notice at the time of retirement is also liable as partner by holding out. In case of partnership by estoppel, the representation is made by partners about a stranger within his knowledge and hearing, and he does not contradict it. He is then held liable as a partner. Effects of holding out. The holding out partner becomes personally and individually liable for the acts of the firm, but he does not become a partner in the firm and is not entitled to any rights or claim upon the firm. An outsider who has given credit to the firm thinking him to be a partner can hold him liable as if he is a partner in that firm. As the liability of the partners is joint and several, he can be held liable to pay the entire amount. But under the doctrine of subrogation as well as on the basis of quasi-contract, he can recover the amount so paid from the partners of the firm if they are solvent. Exceptions to holding out. The doctrine of holding out is not applicable in the following cases. Number 1. It does not apply to cases of torts committed by partners. A person, therefore, cannot be held liable for the torts of another simply because that other person held himself to be his partner. Number 2, it does not extend to bind the estate of a deceased partner, where after a partner's death, the business of the firm is continued in the old firm name under section 28 subsection 2. Number 3, it also does not apply where the holding out partner has been adjudicated insolvent under section 45.